Larry Dean Brown, a 79-year-old Colorado man, has now been indicted on a murder charge in the 1981 death of Beverly Bruneau, a 35-year-old Braniff Airlines flight attendant found dead in her Grapevine, Texas apartment more than 45 years ago. The newest court update goes beyond the original arrest headline. Brown's bond was reduced from $2 million to $100,000 on July 17th. But Tarrant County's official inmate system still listed him in custody on July 18th. The central question is how DNA recovered from discarded soda bottles revived a case that had been unresolved since 1981, and what that evidence does and does not establish at this stage. For verified entertainment updates without the rumors, subscribe to Startline Entertainment. The public timeline begins on February 13, 1981. According to the arrest warrant affidavit described in multiple reports, Bruneau's boyfriend returned from work at approximately 3 p.m. after being unable to reach her. He found her on the living room floor of the Grapevine apartment they shared. The medical examiner determined that she had died from strangulation during the mid-morning, and investigators documented evidence suggesting that a struggle had occurred inside the home. Those details are difficult, but the case should not be reduced to the condition in which Bruneau was discovered. She was known as Beverly Casey Bruneau, was a veteran Braniff flight attendant, and was only 35. The long delay between her death and the current prosecution is what makes the preservation of physical evidence and the decisions made by later investigators so important. Detectives began speaking with people connected to Bruneau on the day she was found. Their inquiries led them to her best friend and fellow flight attendant, Thelma Brown. Thelma was away on an international flight, but her husband, Larry Brown, spoke with investigators. Brown had also worked for Braniff as a pilot and flight engineer. The affidavit says investigators noticed a fresh injury near his right thumb and considered some of his answers evasive, although those observations were not enough to produce an arrest at the time. The affidavit describes a financial dispute involving a Dallas property Bruneau and Thelma Brown jointly owned. Their mortgage arrangements reportedly left both women responsible for the property, and the loan included a form of credit life insurance that could pay a portion of the debt if one owner died. Investigators allege that the Browns were experiencing financial pressure after purchasing another home and wanted Bruneau to sell the Dallas property, obtain another roommate, or release Thelma from her obligations. Bruneau reportedly refused. These are prosecution allegations contained in court documents, not findings reached by a jury. In November 1980, while Bruneau was away, the Dallas house was damaged in 2 fires on the same night. Investigators later considered the fires suspicious and described at least one as arson. Afterward, Larry Brown allegedly handled insurance matters connected to the property and obtained repair estimates through a construction business in which he had an interest. Those figures allegedly exceeded the insurance company's appraisal. According to the affidavit, Bruneau told relatives that Brown was pressuring her to sign insurance paperwork containing inflated repair costs. Her mother told investigators that Brown had argued with Bruneau about the insurance check 3 days before her death, and that Bruneau had expressed fear of him. Brown reportedly acknowledged during a 1981 interview that he had visited Bruneau on February 10th to discuss the documents. None of those claims, standing alone, proves who killed her, but investigators now present them as context for an alleged financial motive. The affidavit further alleges that Bruneau's signature was forged on insurance paperwork after her death. Public reporting attributes that allegation to Thelma Brown, but the sources reviewed do not show that she was charged in the current murder case. That distinction matters. An allegation preserved in an investigative affidavit should not be presented as a conviction or as proof of criminal responsibility by anyone who has not been adjudicated. Brown was interviewed several times in 1981. He said he had met contractors at the damaged Dallas house between 9 and 11 on the morning Bruneau died, and later went to his construction company's office. When questioned about the injury on his thumb, he reportedly said it happened while working. Investigators recorded that they did not believe the explanation matched the appearance of the injury. The affidavit also says that Brown later declined further questioning, fingerprinting, a polygraph examination, and requests to photograph possible injuries. A person's decision not to consent to voluntary investigative procedures is not itself proof of guilt, but the affidavit includes those events as part of the historical investigative record. For decades, the case did not produce a prosecution. Then, in December 2010, Bruneau's preserved clothing and other evidence were submitted for newer forensic testing. A laboratory detected an unknown male DNA profile associated with blood on her nightgown. Investigators uploaded the profile to the FBI's Combined DNA Index System, commonly known as CODIS, but the search produced no match. That 2010 result was important, even though it did not identify anyone. It meant investigators had a profile that might later be compared against a known individual. The problem was that a database search can return only information already available within the database. When CODIS produced no candidate, the unknown profile remained evidence without a publicly identified source. The next major turn came in 2025, when a Grapevine detective began reviewing the investigation again. That review brought renewed attention to the property dispute, insurance records, witness statements, Brown's historical interviews, and the DNA found during the 2010 testing. In February 2026, Grapevine police contacted the Larimer County Sheriff's Office because Brown was living in Loveland, Colorado. Colorado investigators then conducted surveillance and collected items Brown had placed in household trash at the curb. The arrest affidavit described swabbing 2 discarded soda bottles. CBS Texas also reported that the collected trash included a barbecue sauce container, but the affidavit-based reporting identifies the soda bottles as the items used to obtain the comparison samples. On May 28, 2026, the Grapevine detective received laboratory results. The precise phrase reported from the affidavit is that Brown could not be excluded as a contributor of the male blood DNA recovered from Bruneau's nightgown. That wording is more careful than saying the bottle DNA conclusively proved that Brown committed the homicide. It indicates that the tested profile was consistent enough that investigators did not eliminate him as a possible contributor, but the police department has also said additional confirmatory DNA analysis remains pending. This is one of the most important distinctions in the entire story. Some headlines and television reports have described the results simply as a DNA match. The arrest affidavit, as quoted by the Fort Worth Star-Telegram and People, uses the more limited, could not be excluded language. Until the underlying laboratory reports and confirmatory analysis are presented publicly or examined in court, the narrower wording is the most accurate description. Brown was arrested in Colorado on June 8th. A Tarrant County grand jury indicted him on June 29th on a charge of murder, and he was extradited and booked into the Tarrant County Jail on July 14th. Grapevine police publicly announced the development on July 16th. The indictment alleges that Brown caused Bruneau's death using his hands or an electrical cord. An indictment is a formal accusation authorizing a prosecution. It is not a determination that the accusation has been proven beyond a reasonable doubt. The Tarrant County District Attorney's Office said the case involved cooperation between Grapevine Police and the office's newly formed Cold Case Task Force. Prosecutors described the arrest as an example of agencies continuing to pursue cases regardless of how much time had passed. But police also made clear that their investigation was continuing and that they were waiting for additional forensic results before providing more details. Brown's initial bond was set at $2 million. His defense attorney, Brian Holler, filed a motion asking the court to lower it, citing Brown's age, medical concerns, lack of a prior criminal record, and the length of time he had already spent in custody. The defense also characterized the prosecution's evidence as largely circumstantial and argued that many witnesses referenced in the affidavit are now deceased. The defense directly challenged the significance of the DNA evidence. According to the bond motion as reported by the Star-Telegram, the defense argued that even a confirmed association could potentially have an innocent explanation because Brown and Bruneau knew each other socially. That argument has not been tested at trial, but it previews an issue likely to become central. Prosecutors would need to address not only whose DNA was present, but when, how, and under what circumstances it was deposited. On July 17th, the court reduced Brown's bond to $100,000. Reported conditions include GPS monitoring, house arrest, and permission to travel for medical appointments. That decision does not resolve the strength of the evidence. Bond proceedings concern pretrial release, flight risk, safety, and appropriate conditions while a case is pending. They are not trials on guilt or innocence. Despite the reduced bond, Tarrant County's official inmate page continued to identify Larry Brown as being in custody when checked on July 18th. That could change if he posts bond or if the court modifies the conditions, so any published video should describe the custody information with a clear date rather than treating it as permanent. Another detail requiring care is the date of Bruneau's death. NBC's report contains a reference to February 10th, but People, CBS Texas, and the affidavit-based Star Telegram account say she was found on February 13th. February 10th appears elsewhere in the timeline as the date of the alleged argument over the insurance paperwork. Based on the weight of the reporting, February 13th is the date that should be used for the homicide. What happens next has not yet been fully announced. The sources reviewed do not identify a trial date or a publicly entered plea. Confirmatory DNA testing was still described as pending, and the prosecution and defense have offered sharply different interpretations of what the available evidence means. Brown is presumed innocent unless and until the charge is proven in court. The start line takeaway is that this is not simply a story about a discarded bottle instantly solving a case. The arrest followed several separate stages. Evidence was preserved in 1981. Newer testing developed an unknown male profile in 2010. A detective reopened the case in 2025. Investigators collected comparison DNA in Colorado in 2026. And a grand jury later approved a murder indictment. Each stage added information, but the final legal questions remain unresolved. What changed now is that Beverly Bruneau's death has moved from an open cold case investigation to an active criminal prosecution with an indicted defendant. What viewers should not assume is that an arrest or DNA association equals a conviction. The next developments to watch are the confirmatory forensic results, Brown's pretrial status, any formal defense filings, and the scheduling of future court proceedings. For Bruneau's family, the arrest may represent the first possibility in decades that evidence will be examined in a courtroom. For the justice system, the case will test whether preserved evidence, historical witness accounts, and modern DNA comparisons can still produce a reliable verdict after 45 years. And for now, the most accurate summary is also the most restrained one. Larry Dean Brown has been indicted and remains accused. The defense disputes the case, additional testing is pending, and no verdict has been reached.